looks like we're having trouble over on Rumble. Let me go mess with the stream key.
Should I start here?
Yeah, go ahead.
Okay. Hey, good morning, everybody. Welcome back to Law and Legitimacy. It's Friday. It's been a busy week, and technological difficulties abound, and some human ones, too. I was lollygagging around this morning thinking I had time to spare, and I get a text message from Mike. Are you coming this morning? I look at my watch at 7:57. I get in. I can't log in, of course. I have to figure out how to do that, and, of course, Rumble now is giving us difficulties. So, Mike, you can see over there busily at work trying to hook us up with Rumble. Maybe it'll happen. Maybe it won't. But you're here. Thank you. Good morning, everyone. We're still dealing with the aftershocks of the Trump indictment. But here's one thing that I am certain of, and I'm going to urge everybody to make this your mission. I want to try to create a groundswell of a call for a televised trial. I can't see any reason in the known universe why the federal judiciary cannot consent to having cameras in the courtroom in the case of United States of America versus Donald Trump. This might be the most significant trial in the nation's history, dwarfing even, John Adams' trial where he defended the British soldiers in the Boston Massacre case. It might be more significant than the Scopes monkey trial, where Darrow defended John Scopes for teaching evolution. It certainly will capture more interest than the case of People of California versus O.J. Simpson. At stake in this case, and the indictment is a bold document. Basically, what it says is everything that Donald Trump has told you about election interference is a lie, and here's why. And this is the trial that the government seeks to put on. And it seeks to put it on not just to indict Donald Trump and presumably secure his conviction, but to persuade the rest of us that all is well with the electoral system. Well, you know what? Let's see it for ourselves. The First Amendment to the United States Constitution guarantees the public the right of access to the courtroom. Thus, a courtroom cannot be closed gratuitously. That is, a judge can't just say, hey, we're going to have a private trial. That frustrates the very purposes of having courts and having a transparent system of justice. Of course, we know that courts can and do close courtrooms and have secret proceedings when it suits them. We saw this repeatedly in the Proud Boys trial, where when it came to information about confidential human sources embedded by your government in right-wing groups, the court concluded that some truths were too hot for the public to handle. I disagree strenuously with that conclusion. Reporters and lawyers challenged the court's conclusion or decision to close the courtroom, and they lost. And that will be a topic that might be reviewed on a different day. Additionally,
we should be live on Rumble now, so want to welcome everybody in who's streaming in through Rumble. Sorry about that technical difficulty, but we should be all good now. We're patched up.
So for those of you who Rumble made late, what we're talking about is the case for cameras in the courtroom in the case of United States of America versus Donald J. Trump. This will be a significant trial, and I think we all want to see it. And I think the government wants us to see it. They want us to see it because of the nature of the indictment. It is a sweeping attack on Donald Trump, calling him a liar. I'm basically saying he knowingly sold a bill of goods that he knew to be false to the American people. I suspect he'll say otherwise, and he has a defense to put on as he runs for president of the United States, and while he leads the incumbent in many polls. So what we have is something unprecedented. Well, not altogether unprecedented. What we have something is that's almost unprecedented in American history. We have an American president, an American presidential candidate running for office while under cloak or under cloud of a federal indictment. We have had men run for president from within prison. Eugene Debs famously did so for socialists a century ago, capturing 3 or 4, I think maybe even 5% of the vote, which was an extraordinary sum. And no one expected Debs to win. At most, he would play spoiler. But now we've got the leading candidate for one of the country's major parties, basically charged with a new crime, disinformation, and by the incumbent party. And I think that from a political perspective, Everybody who cares about the electoral process and about the republic should want to see this trial. And so what are the arguments against cameras in the courtroom? There's no foundation for it in the First Amendment. The First Amendment guarantees public access to the court. The Sixth Amendment as well guarantees a defendant a speedy and public trial. Now, the argument that the courts will make, and those who oppose cameras in the courtroom, is that no one said these are private trials. You want us to come see the trial? Show up. And if we've reached seating capacity, well, we've opened it to the public. There's not much more we can do. In a so-called high-profile trial, the court will have a media room where members of the media can sit in another room and watch a video delay of the trial, so that they can report on it live. But here's the hypocrisy of this rule. We can't have cameras in the courtroom because they'll be disruptive, but we can have a media room where a video feed of the trial is fed to people sitting in another room. Why not flick one switch and send that video feed to the American public? It is not going to be disruptive. It is not going to interfere with court proceedings. We already have a video feed of the trial. It used to be years ago, I opposed cameras in the courtroom on the grounds that they would be disruptive. And I feared, frankly, their impact on me. I'm a ham. I go to court and I'm acting up and I'm putting on a show. And I worried that I'd be putting on a show for the camera, and that would be distracting and perhaps to the detriment of my client. What I learned in Connecticut, where there are televised trials, is you almost immediately forget that there's a camera in the room at all. Trial is so engrossing. You're worried about the witness, the court's ruling, your adversary, the perception that is being made on the jury. And so there is no argument to be made that cameras are disruptive. I'm unaware of any case since the Sam Shepard case in the 1950s, where the media's presence in a courtroom has held to be so disruptive that it required a new trial. So I'm asking each of you to talk it up. Let's talk up a public trial. Let's have a public trial. Let's hit the switch and show the feed to the public. I don't want to rely on a reporter's interpretation of what he or she sees in the courtroom. I want the right to see it for myself. And in these divided times, a speedy and public and publicized and televised trial will do more to help heal divisions in this country than anything I can think of. Because otherwise, we're going to be relying on reporters to tell us what they see. And let me tell you something. Much though I have respect for the press and the press corps and court reporters, it is almost always the case that when I have been in trial and looked then at the press coverage of the case, I don't recognize parts of the case. The press almost always gets it wrong, not intentionally, but just because there's so much going on. So, let's let the public make up its mind for itself.
Well, and what I've put on the screen, thank you, Cindy, over on YouTube. Cindy said, I saw something on Twitter where Schiff and other Congress members wrote a letter to the Judicial Conference asking for a public trial. What I put on the screen, Norm, is just that. This is dated yesterday, August 3rd, 2023. The Honorable Rosalind R. Moskompf, if I butchered the judge's name there, my apology. Quote, we are writing to request the Judicial Conference explicitly authorize the broadcasting of court proceedings in the cases of United States of America v. Donald J. Trump. It is imperative the conference ensures timely access to accurate and reliable information surrounding these cases and all of their proceedings, given the extraordinary national importance of our democratic institutions and the need for transparency. As the policy-making body for the federal courts, the Judicial Conference has historically supported increased transparency and public access to the court's activities. Given the historic nature of the charges brought forth in these cases, it is hard to imagine a more powerful circumstance for televised proceedings. If the public is to fully accept the outcome, it will be vitally important for it to, bless you, Norm, for it to witness as directly as possible how the trials are conducted, the strength of the evidence adduced, and the credibility of witnesses. We urge the conference to take additional steps, including live broadcasting, to ensure the facts of this case are brought forward unfiltered to the public. Sincerely. And then you've got a number of members of Congress who have signed this letter?
Well, that sneeze you heard was me realizing that I publicly found myself in a forum agreeing with Adam Schiff.
Right. Yeah.
I'm allergic to that, but I think he's right. I think the congressmen are right. This is a trial that requires publication, and it should be televised, and there's time to get it televised. I don't know what the schedule will be. Trump was arraigned in court yesterday, and according to press reports, again, because I couldn't see it for myself, but according to press reports, the arraignment more or less went off without a hitch, although Trump was said to be irritated when the judge referred to him as Mr. rather than President Trump. Parties are due back in court on August 28th to address scheduling. The court directed the United States government and the defense to respond within 7 days with a proposal about how long the trial would take and when the parties would be ready for trial. Trump's legal team said, whoa, wait a minute. We haven't even seen the discovery yet. We haven't had a grand jury impaneled for months, secretly looking at information, gathering documents. We haven't had our team of lawyers spend time combing through a record to make the best possible case and to put it in the form of a 45-page indictment to drape before the public. We want to see the discovery. We might need more time to come up with an estimate of what is and is not reasonable. The judge, who is a harsh judge, I forgot her name just now, Chutman, I think it is. She's regarded as a hardliner on J6 cases.
Moskopf?
No, that was the magistrate judge. Yeah. The Article 3 judge is a former federal public defender with a little bit of trial experience, some 30 trials, and she said she argued some appeals, in her brief tenure as a public defender. But she's going to be under some pressure by Smith and Company to put the case on immediately, and to the degree that they put the case on. They put pressure on to try it immediately. It begins to look like political theater. Let's get it done before the election. Let's maximize the harm to the president. Let's see if we can get him convicted and potentially even disqualified, which I don't think a conviction would in this case before the trial or before the election begins. My view is the Trump team has had a lot of time to prepare. This has been widely reported on. He changes lawyers like people change deck chairs on the Titanic. And his team may not be ready, but candidly, they should be. He's rumored to have spent, I think, 20 or 40, I can't remember, $1 million on legal fees in the last year. What have these guys been doing? Eating at fancy restaurants? If they're not ready for trial, shame on them. And if his message to them should be, let's try it now. And he should make this into a campaign event. We'll see if he does.
So put some of the biography there for the judge in the case. The few things that I've seen in passing on social media have been of a political bent, obviously. Judge Chutkan, I believe, was an Obama appointee. And then there was also something circulating, Norm, and you may be able to provide some insider clarity to this, but that in the January 6 cases brought before this judge, she is the only one that has increased the sentences sought by prosecutors in the convictions for January 6 defendants.
Well, that's an interesting point. I hadn't seen that. So, as regular listeners know and experienced practitioners know, under federal law, sentencing guidelines dominate the proceedings. Sentencing in 1984, Congress created sentencing guidelines to eliminate broad discretion among judges. The thinking was that if there were uniformity in sentences across the country, it would increase respect for the rule of law. People didn't understand, why, some people got 5 years for an offense, whereas somebody else got 40 for the same offense. It's a humorous anecdote. I frequently get calls from people saying, hey, how come they want me to do 30 or 40 years for this killing? I know a guy who got 5 years for that. And whenever I hear somebody say that on the phone, I say, stop right there. Find the lawyer who got the guy 5 years for a case that looks just like yours. I'll give you your money back and go hire him, because I can't do it, And but the sentencing guidelines were supposed to create uniformity. and they were mandatory for a while. They are now no longer mandatory, but they are advisory, and courts must consider them in their analysis of a sentence. So the way federal sentencing works is upon a finding of guilt, whether it be by a jury verdict or a plea, pretrial service officers do what's called a pre-sentence report, identifying factors which under the guidelines would call for a sentence of one term or another. It's proposed, the parties review it, they work out differences, it's submitted to the court, the parties then do sentencing memoranda, and at sentencing, the court then must accept the sentencing guidelines or make factual findings about what factors will drive the sentence. Once that's done, the court then considers the guidelines and imposes an appropriate sentence. Chutkan, apparently, Mike, I haven't been that close a student of that part of the J6 sentencing game yet. I haven't had to endure a sentencing. I will at the end of the month. Chutkan has apparently been departing upward. That's how you look at the guidelines. You either depart downwards, impose a guideline sentence, or depart upward. She's been so outraged by it all that she has given non-guideline sentences that exceeded the recommendations of probation officers. That's bad news for Trump.
It is. I think it is. I believe that what I was talking about yesterday in terms of the broad scope of discovery, that was something in the back of my mind, knowing that I had read in passing, and Severe Conservative says here, she has apparently delivered harsh lectures when sentencing the January 6th defendants. What I was probably thinking about is ultimately the departure from the sentencing guidelines, up or down, is sort of it helps us understand the judge's state of mind, which is what you were just describing. And
well,
for that reason, it may be that evidentiary standards, admitting certain pieces of evidence will be more or less difficult depending on where she is sitting in all of this. So hopefully it, I think going back, it is crucial that the trial be televised. I brought up earlier, and I'm going to share it again, the poll that you put up on X. The federal courts prohibit televised proceedings. That antiquated policy needs to change. We are prosecuting a former president and current presidential candidate. The public not only has a right to know about this, we have a right to see it. Televised Trump. Do you agree? 93.8%. And this is as of this morning. Almost 1,800 votes with 93.8% agreeing that it should be televised.
Yeah, and one of the dissenters, I said, if you want to see it, go to court. I mean, I understand that's the traditionalist view. I just think this trial is too important. I would make time to watch it. We had one comment that really stuck with me from a couple days ago when I was trying to discuss the indictment and what it meant. And somebody said, well, so the way the government will proceed in its proof is to say that Trump knew or should have known, and in fact did know, that what he was saying was a lie because other people told him the truth. And somebody said, well, is he obliged to accept as true what others tell him? Well, no. He's not. But I do think that at some level, if we live in a community of common norms and values, we have to understand that there is something called reality out there, and that we might be able to reach agreement about what it is. Now, the standards may differ and vary, but I would like to see for myself the testimony of those that the government is going to use to try to prove that Trump knew he was lying when he made these utterances. I'd like to see the cross-examination. I'd like to see how Trump reacts. And I think the American people should demand this. This is one of the few times where I would call for a sort of populist uproar and an attempt to change the behavior of the courts.
Well, I think that the transparency letter to the judicial conference is a great sign. Like you said earlier, it's not often that you have an opportunity to agree with Adam Schiff on really anything. And it certainly seems as though both parties recognize now that the 2024 election campaign for Donald J. Trump is going to be hashed out in the court.
Well, and that's the thing that I just can't forgive about this prosecution. I mean, we've said it here before, we'll say it again. In the post-Civil War world, where 600,000 Americans were killed as a result of the violence of a 4-year war that literally tore the country apart. Within 3 years, we were granting amnesties and welcoming rebels back into the republic if they swore a loyalty oath. 2.5+ years after January 6th, we're still roping in new defendants, and we're still trying to punish people for what amounted to a 6-hour disruption of the Electoral College proceeding at a time when it was expected that the electoral proceeding, the counting of electoral votes, would take days. One of the things we learned during the Proud Boys trial is one of the reasons law enforcement presence on Capitol grounds was not as robust as it could have been on the 6th is they were marshaling resources. They had people held in reserve because they expected to go round the clock for 2 or 3 days, and they couldn't have each person serve every hour. So they had some people stay at home to come in on the second shift, as it were. So to suggest that this was the disruptive event that requires these long-term felonies years after the event is not persuasive. What is persuasive to me is that it took 2.5 years to focus on the president, and he was charged at a time when it makes it just possible for this trial to take place before the general election. And so, I'm not one to see conspiracies, but you do have to question the timing of the Biden administration's decision to bring this action just before the general election. And so Donald Trump should call his bluff. He should, and I don't know that he's going to do it. His lawyers are adopting an old page from his playbook. Delay, 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 delay. This is a time where Donald needs to think outside the box he's confined himself in. This is not a prototypical standard piece of litigation. This is historically unique litigation, and he should be thinking the same sort of thoughts as he thought when he went down the escalator in 2016 from Trump Towers in Manhattan to announce his presidential campaign. Here I am, deal with me. You pick this fight, I intend to win it. And I don't know whether Donald Trump has, quite frankly, the cojones to wage the sort of defense that he should wage in this case. If he bobs and weaves and files motions and changes lawyers a couple times.
Yeah, it's an interesting point, Norm. And what does he have to lose at this point? I think is really appropriate. I know that sometimes that's a trite sort of rhetorical question, but I do think that at this point, this is the pinnacle of the drama that we've witnessed since 2016 and his being elected.
And it cannot be that this indictment takes him by surprise. The underlying facts that support it are old, and Smith has given him a playbook. Donald Trump's lawyers should appear in court on the 28th and say, we're ready for trial next week. Is the government? You pick this fight, we intend to win it. So Donald, if you're listening, kick your lawyers in the rear end. They seem to be good. I don't know a lot about John Lauro from California or from Florida. I admit I looked him up the other day with a certain sense of almost, I don't want to say jealousy, but professional curiosity. Who is this guy and how lucky is he to have a seat at the table in this historic trial? So let's see what happens. Let's see what happens.
Some jury nullification.
Yeah. So if this case goes to trial, and it will, this would be another ideal occasion to test an historic doctrine. Does the jury have a right to decide the facts and the law in this case? And the jury nullification is a doctrine that says that juries can acquit notwithstanding the evidence. In other words, jurors can regard what the government has, the charges that the government's brought, and the proof that the government marshals. And jurors can say, look, the government's proved its case, but we're not going to convict because we think the government was wrong to bring the case. The famous case in the United States history of jury nullification is the prosecution of John Peter Zenger, a publisher in colonial times in New York, who published information hostile to then Governor Clinton, no relation to Hillary or Bill. And he was prosecuted in effect for sedition because it was against the law to publish comments that were hostile to the government. And his defense was, look, I spoke the truth. And even though it's against the law to speak the truth should will out. And the jury nullified it. In other words, the jury said, we disagree with this law and we refuse to convict. I think that in Trump's case, he should be able to put on a political defense, and he should be able to question the government's motives in filing this case when it did and in the forum that it did. And that should be a vital part of his defense. The trial judge almost certainly will not permit it, because although his motives and everything he said gets to be used against him, courts are quick to say when you challenge the government's motives that the government isn't on trial here. And of course, that's bull. I mean, the government is on trial. Read the caption. It's United States of America versus Donald Trump. Its motives for bringing this case when it did and in the forum in which it did should be questionable. We've got a question from Severe Conservative. Any hope with a DC jury pool? Would seem no. The DC jury pool, DC is a company town. Let's not forget for a moment, it's not a state. You see bumper stickers in DC, taxation without representation. Yeah, maybe. But you're living off the public trough. Washington, D.C. is the only municipality, as it were, that's created in the federal Constitution. And it was designed to place the federal government there so that the federal government would not be the captive of any state and would have true independence. Okay, it's got true independence of any state, but it's got utter dependence on the federal government. You're either a federal employee or working supporting federal employees, or working trying to influence federal employees. During the Proud Boys case, we were stunned to see how many people were either lobbyists, new lobbyists, or had people who worked in federal office buildings or worked for Congress or had strong views about the government. Normally in a federal jury selection, it takes about half a day to pick a jury. It took us 12 days to pick a jury in the Proud Boys case. And that's because people had such strong feelings about participants in the trial, including President Trump, that it was difficult to find people who would commit to be fair and impartial. We did a motion for a change of venue. And the court denied that motion. In other words, a change of venue, meaning moving the trial to a location where there would be a different jury pool. The court denied that. Whether anybody chooses to take that up on appeal, I candidly think it's a losing issue under the facts of that case. But one of my co-defendants may disagree. So I think there's an overwhelming likelihood of a conviction in D.C. with a D.C. jury. And I think that nullification may be Trump's only real hope. And he needs to say to the jury, look, this is unprecedented. This is an effort to politicize, to criminalize political differences. What the violation of civil rights claim that he's facing is similar to charges that were brought against a private individual named Douglas Mackey. After the, I believe it was 2020 election. He posted on social media a site basically saying, look, you cast your vote for Hillary here, basically avoid the inconvenience of going to the polling place. Vote now, vote online. And many people did, and presumably didn't turn up at the polls. He was charged by the government with interfering with people's right to vote. But basically what the charge came down to was using trickery or disinformation. And that's the same claim that's being brought against Donald Trump in the notion that he's defrauded the United States government. Normally when we think of fraud, we think of taking money or something of value from someone else. Under federal law, that charge can be supported by engaging in dishonest behavior or trickery designed to disrupt a government function, in this case, the collection of votes. When has a sitting politician, and I guess we end more or less where we begin, when has a sitting politician in this country, a politician running for office, ever been charged with basically mis or disinformation? It's never happened. And so those who are railing against the prosecution of Donald Trump on First Amendment grounds are focusing on this. And it's an important argument. And I think it's an argument that needs to be taken to the jury. You're taught in law school that in order for a case or controversy to go to court, it has to be justiciable. That is, there has to be something that the jury can rightfully decide. One exception to one of doctrine that courts use to avoid deciding a case is the so-called political question doctrine. It seems to me that the prosecution of Donald Trump in this case should be derailed on the political question doctrine. And I fully expect his lawyers to file a motion to dismiss on those grounds. That what he said while in office, in pursuit of remaining in office, and the voters have spoken, and therefore this is a political question that is non-justiciable. Photography writes, there was an article in the Connecticut Mirror yesterday saying that Trump can be elected from prison, and the answer is he can. There's no prohibition on that. Mike Cernovich had a fascinating and funny comment the other day. He admitted,
I saw that you retweeted that.
Admitted it would be cool to have a guy elected president from prison or something. It might be, The interesting fact about these charges is that Smith and Company didn't charge seditious conspiracy, which arguably could have disqualified Trump under the 14th Amendment, Section 3. Which talks about not being eligible for federal office if you've been convicted of engaging in violence against the United States government, which is meant to include insurrection, which arguably could include seditious conspiracy. Again, all arguments that would have to be made along the way. But Trump could be elected from within prison. So, my view is
tweet. Very funny. Very funny.
Like when he hits the ball hard, he hits it out of the park.
Yes, he does.
So, eventful week in Trumpdom and in the country, raising questions about public trials, what happens at trials, whether jurors should have the right to nullify, whether you can get a fair trial in a captive company town. And I guess we're going to find out answers to all of these questions in the weeks and months to come.
Photography wants to know if Trump's cell would look nicer than Al Capone's.
I don't know. What would they do? I mean, he's entitled to Secret Service protection. So would Secret Service agents, would they do a wing of the prison for him?
Would just get to jail from the Secret Service.
Would he forfeit the Secret Service, protection incident to his presidency? I mean, I agree that no one should be above the law. But in this case, I don't think politics should be strained through the prism of the law. And if we're going to regard politicians as criminals, then people who support politicians who are accused will regard the law as the true criminal. And thus the republic dissolves one prosecution at a time.
Truer words, Norm. I've had a great time this week. We've hit a lot of very cool stuff, and I think we've made some strides. Rumble is the Rumble chat's always great. Liberty Warrior, sorry we didn't get to you sooner, but he was talking about I think on the lines of Trump's political speech. He said they act as if Trump was the only one saying these things. We all saw it. There were tons of people talking about discrepancies. Detroit, Philly, Atlanta, Phoenix. We all saw the graphs. It's ridiculous. And I think that is something that just goes back to like I said, sort of the issue of Trump not being the source of the arguments being made on behalf of the discrepancies and stuff like that. And it's, to me, his defense team will have to deal with that head on.
And then we've got to deal with the consequences of this disinformation indictment. If he is charged, if he is convicted, then who's to say that you won't be next if you advance a similar proposition? If you advance a proposition that you believe, but somebody else believes is untrue, will you be prosecuted for saying something that's not quote unquote the truth? And who decides the truth? These are troubling times.
Indeed. Well, we will be back on Monday, 8 a.m. Eastern, Rumble video, YouTube Live, X Live. And if you are unable to join us live any of those days, you can always find us over on Apple Podcasts, Spotify, Google Play, Overcast, Audible. Leave us 5 stars and a nice comment, or just leave us alone, as I like to say.
Light up or leave us alone. Right?
Yeah, that's right. Norm, anything else from you before we head out of here?
No. Enjoy the weekend, everybody. We'll see you on Monday.
Awesome. All right. See you, everybody.